Hey guys, Troy Dooley, the Beachside CEO. We just got an update in. Now, this happened on May 30th, but as a lot of you guys know, we've been dealing with some family health issues, so I've not been fully engaged like we usually are. But this just came in, Federal Trade Commission versus iMarkets Live. They have filed a 7,000 page uh, injunction, proposed preliminary injunction against the company. Now, at the same time they did this, there's been some settlement talks in the background. We're going to get into them towards the end of this. I'll try not to keep you guys real long. I want to get into some, not all of it. I'm going to go through some highlights here. Um, the FTC says, as demonstrated by documentation of the defendant's advertising documents and information provided by the defendants and the plaintiffs and submitted in support of plaintiff's motion for preliminary injunction, testimony from defendants' employees, consumer declarations, a report of the plaintiff's survey expert. This expert report was over 500 pages long, and additional documentation. Truth in Advertising, Bonnie Patton, she's got three declarations in this that, matter of fact, let me grab that real quick. They accumulate to over 700 pages of documentation that Truth in Advertising had put together, all part of this 7,000 page injunction. Some of the, I'm looking here, the investigator, undercover investigator for the FTC, I believe, I mean, he made up the bulk of this, which was over 5,000, I think, documentations and all of this. And they have used, I'm looking on here, they've used forensics accountants, all kinds of people. So this is all in. They literally are showing the judge why this needs to be shut down now that the companies closed their doors, and how to protect the documentation. Their biggest concern right now is that with the closure of the company, documentations, recordings, videos, and all that will be destroyed. And they mention that in here. It says, for good cause to believe the immediate irreparable damage to the court to grant effective financial relief to consumers, including monetary refunds. They're trying to make sure that any hard assets are not sold or disposed of, transferred to third party offshore trusts. They're trying to make sure that any money that is there stays in order to give refunds, to make sure that anything that needs to happen has happened. It's pretty interesting. It says good cause exists for appointing an independent monitor. Now, this one is, I find interesting. They're not saying they want to put it in receivership. They're saying they want to have the company stay as it is, shut its operations down, and have a monitor come in with full access to everything to make sure that everything's done in an orderly fashion while this case proceeds, which is actually a good thing. You know, a lot of times, and we've had this in both public and private comments already on IML. People have asked, will we get any of our money back? Is there anything to get back? Well, that one's a tricky one because people's money shouldn't be in the company. It should be in independent trading accounts. Will they hold the company or the individual defendants responsible for loss of funds? That's a question. They've now put up on the government site the non-redacted complaint, which now shows Brandon Boyd didn't have as much money, it seems like, invested as he said he did when he was an educator. It looks like about $1,500. So, I mean, there's a lot of stuff here that's going to come to the surface that now we've got to look at as the network marketing community. Were the people that were the leaders of IML, were they telling the truth? Did they really make all this money they said they made from trading, or was it from the sale of the memberships? It can be from the sale of the memberships, but you need to disclose where your money came from. And you guys have heard me say in the past, I had friends that were there before I came into the company. There were friends there when I was the contracted director of compliance. They made money trading. There was some good educators at the time that have left that have been clients of mine. This is an accumulation of what happened after I left. About the same time I was leaving, the end of 18, the beginning of 19 is when this investigation took place. and we see what the demise has been. I'm going to go through, like I said, I'm not going through all of the 7,000 pages, nor just the 27 pages of the preliminary injunction. I do want to look at what is it that they're prohibited from doing if this injunction takes place. They're prohibited from the release of customer information. So IML itself, um, corporate, let me see if it says that. It says it's further ordered the defendants, officers, agents, IBOs. So nobody, anybody that's connected to this, anybody that's in the field, if you start seeing someone trying to sell the database and they say this is the IOVA or the IML database, we want to sell it, that's stolen property is if the injunction takes place. The company can't sell it. Chris and Isis Terry can't sell it. Brandon Boyd can't sell it. Matt Rosa can't sell it. Jason Brown can't sell it. No one can sell it. So if they come to your company, they say, "Hey, man, we want to come to work with you now. We want to make this money." I don't care if they're a defendant or otherwise. They cannot sell that database, and you need to know that. Preservation of all records. It is further ordered the defendants, officers, IBOs, etc., cannot destroy, erase, falsify, write over, manipulate, conceal, alter, transfer, or otherwise dispose in any manner, directly or directly, any documents that can have to do with the business practices. And it goes on. I mean, literally, the live recordings, any event that took place, any WhatsApp, they go is so deep into that. It says preservation of defendants' assets. They can't sell more than $75,000 of accumulative assets. That's another thing that's very interesting here. The corporate, they've got an asset freeze on the corporate defendant. So that would be IML, any IML affiliate companies in the UK or anywhere else. They can't get rid of that. Any crypto accounts, anything that would be classified an asset of the company. A lot of times when they're young businesses like this, and even though this looks like it's $1 billion scheme or a consumer scam, as they say, fraud involved, the assets like the cars, the planes, and all that stuff will be in a corporate name. It won't be in the individual's name. And they're saying you cannot get rid of any of that. It goes so far in here to say that if you've got any offshore assets, you have to disclose that. That also is tricky. There are certain jurisdictions within the globe where you can set up offshore corporations, offshore trusts, move assets into there, and then try to state, hey, I don't really own those assets, so they're not my assets. A lot of times they try not to disclose that. In this preliminary injunction, it says even if there's third parties controlling those assets. So they're really looking for a way to find everything that's in here and let it go. Now, there are some exceptions. It says exception to asset freeze over corporate defendants. Uh, what they're saying is notwithstanding the freeze, here's what they will allow. They allow paying all employees other than the defendants themselves their usual current salaries, pay the current monthly and other periodic payments paid to individuals who serve as regular instructors. It's interesting here because the company's saying it's shutting down. The FTC saying we'll allow you to stay in business here. Pay compensation to IBOs as calculated under Defendants International iMarkets Live IWOVA compensation plan. Pay interest, pay for the internet services, make payments to fulfill federal, state, and local tax obligations, pay the employer's share of health insurance benefits, uh, but it has a caveat: provided that none of these are over $10,000. So they're saying stay in business, keep going. Let's work through the courts in this thing. The company was saying we're going to shut down. And I think that's what really triggered this is the FTC and the state of Nevada said, wait a minute, if they're shutting their doors, if they say they're going to pay off the defendants, that means people could go different directions. All of a sudden, boxes of records could get lost or stolen or disappear. And we've seen this in many cases that drag on for a long time and the company go out of business. It says duties of the asset holders and other third parties. It's further ordered that any financial or brokerage institution, electronic data host, credit card processor, payment provider, merchant bank, acquiring bank, independent sales organization, third party purveyor or processor, payment gateway, insurance company, business entity, or person who receives actual notice of this order that all hold, control, and maintain custody of an account. They have to hold on to it. They can't give it to, they can't give it back to ISIS or Chris or anybody else. The corporate wouldn't matter. They have to hold, uh, preserve, retain the control of that. They cannot just give it back. I want to look at some other stuff here. Financials disclosures. This is a very interesting right here. It says a complete financial statement on the forms attached. Now, like I said, this is 7,000 pages. We're not going to show all this, nor am I posting it on the internet because I just don't want to pay for all that. We've documented it, but it's just, we're not putting it up on the service. You have to provide a financial statement for the individual defendants, uh, financial for the corporate defendants. That means IML, Chris and Terry. That would be Jason Brown, Matt Rosa, and their entity itself. It'd be any of these guys that run under LLCs. That's a new. I mean, most top end networkers run under LLCs now. This is the one right here that's very interesting. Foreign asset disclosures. It is further ordered that within 5 days following the service of the order, and again, this is if the judge decides to grant this. They've extended this until the 27th of June, when both parties have to show why they should, which the FTC has done. And now IML's attorneys have to show why this is not needed whatsoever. And the judge will make his order probably before the first week of July, I would say. This is going to be pretty detailed. They got to provide the plaintiff's counsel and the monitor with full accounting, verified under oath, and accurate as of the date of this order of all assets, documents, and accounts outside the United States. Now, one reason this might be is there for a while, and I don't know if they stopped this, but they would hold events, both from a corporate standpoint, and some of the top team leaders would go to Dubai, other places around the globe. Obviously, IML was in all these other countries. I've mentioned before that Bloomberg and Newsweek, that I've done interviews with them, and really 12 hours of video that we did for a documentary that's coming up on this, because of the international expansion and exposure that IML did, and the destruction that took place with young teenagers and young college kids and young adults internationally. Some went to prison over this stuff. So they're saying wherever your assets are, you have to disclose them, whether it's an individual, jointly, it's in a corporate name, it doesn't matter. They want to know that. Here's another one that I found very interesting. You have to disclose, if this goes into effect, every defendant that's in this lawsuit. And if we go back, let me see if they pump this all. Now, this was a short version. So every defendant that's in here has to disclose any new business activity. So from reading this, it says further ordered the defendants who receive actual notice of this order, whether acting directly or indirectly, are hereby preliminarily restrained and enjoined from creating, operating, or exercising any control over any business entity, whether newly formed or previously inactive, including any partnerships, limited partnerships, joint ventures, sole proprietor, corporation, without first providing plaintiff's counsel and the monitor with a written statement disclosing the name and the domicile of the business, the address, et cetera, et cetera. What they're saying is you can't transfer anything and do anything new. Now, here's where it gets tricky, is because a lot of these guys, as I just said, do business under LLCs. And they're saying you can't go to work for GFU or My Daily Choice or any other company out there under a new LLC without disclosing to us that you've entered into a new business venture of some kind. So this is, it's going to be really tricky for some of these guys because they've already found new homes. I know that Alex has been working with a new company. Matt's been working with a new company. Jason's supposed to be launching a new company. So when you look at all this, these guys are now having to disclose whatever it is that they're going to do. I would go so far as to say they should disclose. I don't know if anybody in America that they might do business with wouldn't know that there's this ongoing case, but I'd even go so far as to say you need to disclose this because this could be a reputational nightmare for a new company that somebody want to work with. I don't think that if you're marketing that it's a wise deal at all. Goes on to say that recording of all live sales events and retention of all sales documents also must be maintained. And I believe that's the bulk of what we want to cover in here. Now, there's a settlement agreement that's being proposed, and this was very interesting. This was just happened in the last couple of days, so this is very fresh, very new. But Jason Brown and Matt Rosa, through their legal counsel, have offered a settlement with the FTC. There's no further documentation to show yet what that settlement might be. That settlement may be public, or it may be under a court order to say we're going to keep this under wraps. Maybe they have additional documentation they're going to provide in the case. Maybe they're going to be key witnesses. Any of this could be part of a settlement for them to be able to go on and maintain and grow their individual businesses. We're going to wait and see. But this was just coming out. We've wanted to stay on top of this. We've got some of these other cases that we're watching. But like I said, due to some of the stuff that's been going on with the family, I've not been focused on this, but I thought this was very pertinent that we get this out here today. So, like I said, we're going to keep this stuff cranking. We're going to keep it going. We'll have a really cool news release on Friday when we do the episode there. It's going to be fun. So, listen, guys, thank you for tuning in. Thank you for keeping us on informed on some of the other little stuff that's going on. Live well and finish strong, and I'll see you on the next one.